Acting on suspicion that Katz was transmitting gambling information over the phone to clients in other states, federal agents attached an eavesdropping device on the outside of a public phone booth used by Katz. Based on recordings of his end of the conversation, Katz was convicted. The question the Supreme Court answers in this case is, does the Fourth Amendment protection against unreasonable searches and seizures require the police to obtain a search warrant in order to wiretap a public payphone? Well, the Supreme Court said yes, a warrant was required. The most important line from this decision is, quote, "The Fourth Amendment protects people rather than places." This case helps us define the concept of a Fourth Amendment search. The primary holding in this case is that a warrant is necessary or a recognized warrant exception to conduct a search anywhere that a person has a reasonable expectation of privacy. Simply because Katz could be seen from the outside of the phone booth does not diminish the expectation that the words he conveyed would not be kept private between him and the other person or the other parties on the other end of the phone. Consider the idea of the consent search. We call it a search, but it's not really a Fourth Amendment search under the logic of Katz. If you give the police permission to search your vehicle, you cannot claim to have a reasonable expectation of privacy in which they could intrude. So the Fourth Amendment is not implicated in consent searches, assuming they stay within the scope of the consent, and the consent was voluntary. The same idea holds true for other warrantless, suspicionless searches, such as plain view searches or open field searches. When there exists no reasonable expectation of privacy, there exists no Fourth Amendment. Or should we say limited, to be on the safe side, there exist limited Fourth Amendment protections.